Welcome, everyone. Good morning. I'm Angela Nwachi-Willig, Dean of Boston University School of Law, and I want to welcome you to today's symposium. On behalf of our faculty, I want to express our sincere gratitude to Linda McLean, our Robert Kent Professor of Law, and Gina Sapiro, Professor of Political Science and Dean Emerita of the College of Arts and Sciences here at Boston University. They prepared a fantastic program that I know you will all enjoy. I also want to thank all of our speakers and panelists who are contributing today for joining this very, very important discussion. And lastly, I want to thank all of you for joining us, albeit virtually, to celebrate the centenary of the 19th Amendment. So I'm delighted that you're here to reflect on the advancements that we've made over the past 100 years with respect to women's rights, and to consider the progress that we have yet to achieve in order for women, and more broadly for people of every gender identity, sexual orientation, race, socioeconomic class, and religion to truly become full and equal citizens of these United States. Over the past week, like many of you, I've been thinking a great deal about the life and legacy of Supreme Court Justice Ruth Bader Ginsburg. There are few figures in recent history who could claim that they more fully represented the progress that women have achieved in this country over the past several decades. And there are few people who actually fought harder than she did to achieve those gains. As we mourn the death of this historic champion of women's rights, particularly during this very fraught political moment, I know it's easy to fall into a sense of despair about what we might lose upon having lost Justice Ginsburg. And yet, some of you may have read in my own reflections on her legacy, Ruth Bader Ginsburg would be the first person to caution us against letting her death distract us from fighting the good fight. She recognized that the road ahead was long, but she was not here to win the marathon alone. Instead, she was running one leg in a relay race toward a more equitable future. And the suffragists who fought tirelessly for the 19th Amendment ran earlier legs in that same relay race. These suffragists were women like Alice Stone Blackwell, a graduate from our class of 1881, who co-founded the League of Women Voters, and who served as president of the Massachusetts Women's Suffrage Association in 1920, the very year that the amendment was ratified. And before Alice Stone Blackwell, there was Layla Josephine Robeson, the first woman to graduate from BU Law, who successfully worked to pass legislation that permitted women to become members of the Massachusetts Bar. And there was Anna Christie Fall from our class of 1891, who is credited as a catalyst for 1902 Massachusetts law that put wives on equal footing with their husbands in cases where they either died without a will. That was a matter that was remarkably similar to some of the matters that Attorney Ginsburg, right? Then Attorney Ginsburg was still arguing before the Supreme Court in the 1970s. And later there were other BU Law alumni who entered the race, like Barbara Jordan from our class of 1959, one of my personal heroes, who was the first Black woman elected to the US House of Representatives from the Deep South, and a recipient of the Presidential Medal of Freedom. And then there is Sandra Lynch from our class of 1971, the first woman appointed as a judge on the US Court of Appeals for the First Circuit. I have little doubt that others in this room could cite similar lists of historical and current figures from the annals of your own schools and institutions. All of them were important runners, carrying the baton to pass on to the next group, the next generation of women. And the list of those who have run a leg in this relay is long. It's a race that stretches back centuries, and there are still many, many miles to go before we reach the finish line. And Justice Ginsburg knew this well. She realized she was but one member of a movement to give voice to the voiceless, and she credited those who came before her. For example, she cited Polly Murray, an African-American woman who coined the term Jane Crow, and who wrote the Bible of the Civil Rights Movement, according to the late Justice Thurgood Marshall. Justice Ginsburg credited Murray for the very strategy that she employed to convince the court that the Equal Protection Clause of the 14th Amendment also applied to women. Speaking of Murray and her colleague Dorothy Kenyon at the ACLU, Ginsburg said, quote, "We're standing on their shoulders. We're saying the same things they said, but now at last society is ready to listen." But Ginsburg also recognized that the march towards justice was not always pure. Despite the monumental gains the 19th Amendment achieved for women's rights, racism loomed large in the suffragist movement. For example, when Black men received the right to vote, though that right to vote came to exist only on paper during the redemption period that followed the Reconstruction era, Anna Howard Shaw, the then president of the National Women's Suffrage Association, declared, quote, "You put the ballot in the hands of your Black men, thus making them political superiors of white women. Never before in the history of the world have men made former slaves the political masters of their former mistresses." And later in the 1890s, Frances E. Willard, a white suffragist who served as the national president of the Women's Christian Temperance Union, proclaimed, quote, "It's not fair that a plantation Negro who can neither read or write should be entrusted with the ballot," end quote. A number of our panelists will speak about the promises and the failures of the women's suffrage movement, including the exclusion of Black women suffragists like Mary Church Terrell. But to paraphrase another graduate of Boston University, Dr. Martin Luther King Jr., the arc of history is long, but it bends towards justice. And this, I do believe. We stand in a different moment now with a different type of momentum, with a greater sense of shared goals and perhaps even a shared vision, even if those things might exist only for a short period of time. So as we reflect today on the 100th anniversary of the 19th Amendment, and as we envision the future course of gender representation and citizenship rights over the next 100 years, including all the complexities and intersectionalities at play, I urge you to think about the leg you're running in this relay race toward justice and how you will prepare the next generation to take the baton when it's their turn to enter the race. Thank you again. Welcome again to BU Law. Welcome to our conference. I hope you have a fantastic day, and thank you for being here.
Okay. Thank you, Dean, for that inspiring and apt introduction. I'm going to make my introduction extremely brief so we can stay on schedule here. I want to thank everyone for joining us. The law school is delighted to be co-sponsoring this event with Department of Political Science. When Gina and I started planning this conference over a year ago, obviously it was a different landscape, and the dean has aptly covered much of what I would say. So I'm just going to say that the issues of voting and political representation are urgent, and we're grateful to have a chance to explore them with you today. I just want to say the structure of the conference today is there are 5 panels. There's also a lunch break with a chance to join some of our speakers for informal discussion. That'll be like a regular Zoom room, so you get to talk with people. During the actual panels, you can ask questions through submitting them in writing. Our speakers' bios are on the website, so we're not going to be giving long intros of our speakers, so we can save the time for presentation and your comments. And if you'd like to tweet about the program, actually someone else has their slides up, so you can use our Twitter, BU_law, #19amendment. I want to thank Sarah Hebert and Elizabeth Clancy in the Communications Department for all their work. I want to thank Kim Bishop and Chase Shelton of the BU Law Review for all their work putting together a special issue of papers coming out of the symposium that you'll be able to find in about a month on the Law Review website. And now I'd like to turn things over to my colleague, Professor Jasmine Gonzalez-Rose, who's moderating our first panel on historical perspectives, which is going to be wonderful. And my colleague has written at length about civil rights, about race and law, and intersectional issues of diversity and inclusion. So I'm very grateful that she's moderating our first panel on historical perspectives.
Thank you so much, Linda. It is such a great pleasure to welcome you to the first panel of this conference. I want to thank Dean Onwuchekwu for those inspiring words, and also to thank Linda McLean and Virginia Shapiro for organizing this conference, which is going to obviously be already, the tone has been set for a very robust and engaging discussion. So our first panel is on the 19th Amendment historical context. So the slides appeared and then I think they disappeared, so let's see if we can get them back one more time. And so I just want to say a little bit about our panelists here. Just clicking to the next slide. First, we're going to hear from Lolita Buckner-Inniss, who is Senior Associate Dean for Academic Affairs and a Professor of Law at Southern Methodist University. Moving on, we'll go to Virginia Shapiro, Professor of Political Science and Dean Emerita of the Arts and Sciences at Boston University. We're then going to pause and we'll have 10 minutes to really discuss and engage in question and answer with those papers before proceeding on to hearing from Corrine McConnaughy, a research scholar and lecturer at Princeton University, and then Boston University School of Law's own Kristin Collins. We'll then have 10 more minutes to focus on those papers and then a remaining 10 minutes to really engage in discussion. And looking at this final slide here, we can see that we'll be able to submit questions and answers using the Q&A icon. So hopefully you can find that. Our idea is we can get as many questions and answers out and really have a great discussion together. So our first panel opens with an investigation and reflection on understanding the history and struggle for the vote and other political and legal rights for women. We're taking seriously the importance of an intersectional understanding of gender and gender politics, and we're paying very close attention to linked politics of gender, race, and class. Ultimately, we are asking, what is the contemporary significance of understanding the history of gender-based politics and political struggles? So we'll now turn to our panelists, each who will have 10 minutes, and I'll be keeping track of the time.
Thank you so very much. It is a tremendous honor to be here to celebrate the centenary of the 19th Amendment. I have reflected a lot on the comments that we've already heard, and what I'm particularly struck with is how when we talk about the 19th Amendment and we talk about women's rights, we tend to talk about it sort of on a continuum where there is a hope that we start with, let's say, a deficit of rights and we move onward and along that spectrum and things get better. But I want to maybe just pause for a moment and sort of draw a concept from, of all things, quantum physics. And I am no physicist, heaven knows, but I am a big fan of time travel. And so I've always been struck by the notion from quantum physics and from astrophysics that there is no specific, historically instantiated, universal now. There is only the past and the present and the future coming together all at once. And so arguably the now that we are experiencing is part of an illusion. And that actually in some respects frames my comments today. The title of my talk, and from my talk, my soon-to-be published paper is drawn, is While the Water is Stirring, Sojourner Truth as Protagonist in the Fight for Black Women's Rights. And one of the things that I talk about there is sort of the past, the present, and the future all coming together. Certainly, I think that all of us here today, both the panelists and members of the audience, would agree that the 19th Amendment is one of the most groundbreaking aspects of constitutional law that have occurred in the history of our nation. Many scholars do, and rightly so, compare the 19th Amendment in terms of its impact and import to the 13th and 14th and 15th Amendments. And certainly, I would agree with that. However, as has already been mentioned, one of the significant flaws, and I hesitate to suggest there would be any flaw in an amendment as important as the 19th Amendment, was that it did not empower all women. Only, for the most part, white women were able to vote after the 19th Amendment. Now, as has already been mentioned in passing, the whole idea of intersectionality is to cause us to think deeply and broadly about the ways in which various identity markers come together. So when we are talking about, and we are celebrating, and we are lauding women's rights, we need to remember that, for example, we need to think about women of color, especially Black women. We need to think about sexual orientation. We need also to think deeply about class and issues of that nature. And so my focus today is on a specific individual who worked well before there was ever the word intersectionality, who worked to remind us all that, for example, race and class had to be thought about in the same context in which we're thinking about gender. And that person is Sojourner Truth. Now, when I say Sojourner Truth, or as I like to say to my law students, if I were to walk into a crowded bar and say, Sojourner Truth, many people, especially most people who've grown up in the United States, would have some broad idea of what Sojourner Truth stands for. But most people would think, oh, she has something to do with the anti-slavery movement. They would recognize that she is Black. They would recognize that she is a woman. They might recall that she had to do with the anti-slavery movement. And there's actually a substantial minority of people who would get Sojourner Truth mixed up with Harriet Tubman, who, by the way, those are the two most famous Black women in US history. So, but let's put that aside. Most people connect Sojourner Truth with her advocacy on behalf of enslaved people. However, what often gets little discussed is the fact that Sojourner Truth was a stalwart in the women's movement, and she did that work not during sort of the more traditionally thought of suffragette period, that is to say, right before the passage of the 19th Amendment, up to say 20 years before, in the late 1800s. No, Sojourner Truth was actually doing her work during the antebellum period. And that alone makes her what I would call, and then what I do call in my work, a proto-agonist. Now, many of us certainly have heard of the word protagonist, someone who is a central figure in a drama or in a narrative. Proto-agonists, however, tend to be something different. A proto-agonist is someone who comes before the protagonist, who prepares the way, who is often just as long suffering and has sort of that whole hero's journey, but a proto-agonist is also very typically and very likely to be someone who is not thought of and who is not spoken of. So again, thinking in terms of time and space and that absence of a universal now, I think it is important that we look at and think about Sojourner Truth and how she figured in this very important movement that we're talking about today. There is a very important thing that Sojourner Truth used to say, and she said it over and over again in much of her oral advocacy. And let me pause here to say that Sojourner Truth's oral advocacy was everything, because like many formerly enslaved people, she was illiterate. She was born in the late 1900s and did not have the opportunity for education. And that fact in and of itself makes her a phenomenal figure when you think about the extent to which she had this vast amount of rhetorical skill. So what we know about Sojourner Truth comes from two significant sources. First and foremost, her oral representations. Second, the memorialization of those representations, often by white women figures. Now, I don't have time to go into that aspect of Sojourner Truth at length, but suffice it to say, there is often a mismatch between what Sojourner Truth said and what was actually recorded. But one thing comes through over and over again, often enough that we can be sure that Sojourner Truth said the following, which I'm going to read verbatim. I come from another field, the country of the slave. They, and she's referring to Black men, have got their liberty. So much good luck to have slavery partly destroyed, but not entirely. I want it destroyed root and branch. Then we will all be free indeed. I feel that if we have to answer for the deeds done in my body just as much as a man, I have the right to just as much as a man. There is a great stir about colored men getting their rights, but not a word about the colored women. And if colored men get their rights and not colored women theirs, you see the colored men will be masters over the women, and it will be just as bad as it was before. I am glad to see the men are getting their rights, but I want women to get theirs. And while the water is stirring, I will step into the pool. And that phrase, while the water is stirring, from which I draw the title of my remarks today and of my related essay, that grounds Sojourner Truth. One of the things that we can say about Sojourner Truth is that she was someone who was deeply religious, and so her phrase is actually drawn from a biblical reference to stirring water and an angel stirring up water in order to heal the suffering and the sick. So we know that that's what she was referring to. But there's another thing that I want to point to before we go on to the other speakers. That stirring water also refers to a common metaphor for the political process. If you look through 18th century and 19th century literature, you will see that men often said, politics is a muddy pool. It is dirty water. It is insalubrious. It is only suitable for men. What Sojourner Truth came to tell us was that women, all women, Black women, white women, women of all backgrounds, needed to step into that pool, whether we thought of that in biblical terms as a healing space or as a dirty and muddy, insalubrious space. And so one of the things I want to say as I head toward the closing today is that where we are now, this now that's not a now, this past, present, and future, this historically instantiated moment, but looking backwards and forwards and in the present, that pool is at the same time dirty and unhealthy and healing. And women need to continue to get into that pool because, as Dina Nwachie-Willig said, with the death of figures like Justice Ginsburg, we are reminded more than ever, politics is, to put it bluntly, a dirty business, but it is the business that will make us whole and healthy as we try to go forward. So I would urge us all to jump into that muddy pool because let me say to you, one and all, the water is definitely stirring and we should fear not, but jump right in. And I'll stop there.
Thank you so much for your comments and thoughts on your paper, While the Water is Stirring, Suffrage and the Past, Present, and Future of Black Women's Rights. Thank you, Dean Buckner-Inniss. I want to now turn to Professor and Dean Emerita Virginia Sapiro, who is going to talk about the power and fragility of social movement coalitions suffragage from 1860 to 1880.
Thank you very much. This is a great lead-in and transition. Sojourner Truth is one of the powerful figures of the story that I tell as well, and she appears in the full paper. This year of the centennial of the 19th Amendment to the Constitution encourages us to tell romantic stories about our history, stories of heroes and villains, individual struggle and perseverance. We have some old stories and newer ones of this type, and we certainly need these. We need to recognize the individuals. But as a social scientist, a political scientist, I'm seeking to make a different contribution. My work uses the substantial research literature on social movements to frame the story instead as an application of theory and research on social movement coalitions. In the paper, I begin with a review of social movement research that's applicable to the case. I move on to some critical contextual aspects of 19th century history necessary for understanding the story. And then I conclude with a brief history of the rise of the independent women's suffrage movement viewed through these lenses. My story ends in 1870. First, on social movements. Social movements are not single organizations. They are coalitions, even loose networks of organizations, groups, and individuals. For a social movement to exist, it doesn't mean that all participants literally work together. Various bits work in loose association, sometimes in parallel, and often with some conflict and even hostility toward each other. The stitching that holds movement coalitions together is fragile. When a movement faces especially deep challenges, one stitch after another is likely to pop open as the underlying differences and even tensions and conflicts across the component parts exert pressure that highlights difference over unity. In the paper, I outline the most common lines of tension within social movements. The women's suffrage movement was afflicted by most of them. The story of the independent women's suffrage movement begins in the anti-slavery movement, where women worked diligently, doing work that expanded the boundaries of their roles. Anti-slavery women, Black and white, became increasingly aware of their gendered position through their work and developed the rudiments of a gender consciousness. As a result, they began to articulate demands about their position as participants in the great emancipatory movement and beyond. Most of the prominent early women suffrage advocates worked on behalf of both anti-slavery and women's rights, but they consistently placed primary emphasis on anti-slavery and on supporting the US effort in the Civil War until the point of emancipation. Most, but not all, male leaders of anti-slavery welcomed women, variously, both Black and white. They welcomed them to be foot soldiers in the fight for abolition. Fewer welcomed them to take leadership positions, including public speaking, and even fewer welcomed them to advocate for women's rights in the context of the anti-slavery fight. African American women were, of course, in a particularly fraught situation, caught between the sexism of male-dominated anti-slavery organizations and the racism of white-dominated women's rights organizations. At the former, they heard that anti-slavery meetings and conventions were not women's rights meetings. At the latter, they heard that women's meetings are not the place for questions of color. The anti-slavery coalition, like all emancipatory social movement coalitions, had successive periods of conflict and rupture. A major conflict, mostly among men, erupted in 1840, partly over the place of women in the movement. The anti-slavery coalition was rocked again in 1865 after the end of slavery. This was largely a conflict among the male leaders over whether the anti-slavery movement had any mission at all once slavery was ended. Or did it still exist to have an emancipatory mission? There was also the question of whether the larger emancipatory mission should include the woman question. Finally, at the end of the 1860s, when the coalition was already too shattered even to merit the name coalition, the advocates of women's suffrage realized that none of their former coalition partners were going to support the right of women to vote in the short run. Not most of those in the anti-slavery movement, and not that most important coalition partner of all, the Republican Party, which was absolutely critical for any change in the law. Any story of the rise of women's suffrage that neglects the Republican Party as a central player is also neglecting the power of the men with power, and thus is very partial at best. Male leaders of the former coalition stripped the women's rights advocate of their most important resources, funding, and newspaper publicity. The earlier coalition was now shattered beyond repair, and the new independent women's suffrage movement arose with itself being a fragile coalition for many reasons. I might end by emphasizing a point that is crucial for framing the whole story: the very deep and broad culture of sexism, racism, and ethnocentrism in America throughout the period that frames these emancipatory movements. Historians, especially Laura Free, have documented that the period from the 1830s on was one of increasing rigidity of gender ideology and gender inequality. Crucially, the concept of citizenship was increasingly masculinized during this period. That masculinization of citizenship actually provided some leverage to the advocates of Black male suffrage, and we can see this clearly in the documents of that fight. If citizenship was a manly thing, if, as white men increasingly argued, to earn the vote you had to have taken up arms in defense of your country, Black men shared that with white men. To include gender equality in citizenship along with race equality among men would shatter that conceptual leverage. We're well aware of the racist and ethnocentrist rhetoric and actions of many of the white women suffragists. It's harder to detect much similarly sexist anti-woman language among those who turned their back on women's suffrage in that period, white men especially, because the idea of women's suffrage was so ludicrous, so radical, it wasn't even worth discussing. Both African American and white men who had been part of the anti-slavery coalition said that denying women the right to vote was simply not as serious as denying Black men the right to vote. Men's votes, after all, represented their wives' interests. As 1870 approached, the fissures in the former coalition and the vitriol among the former partners increased along many dimensions, including racial and gender lines, but also partisanship, region, and views of appropriate political tactics. Any notion that there were any clean breaks in the movement, that there was any simple division between being in favor of further emancipation of African Americans and being in favor of rights for women, or that there were clearly definable differences between those who held racist and ethnocentric stereotypes and those who didn't, is just romantic story making. Nor was the break between the American and National American Women's Suffrage Associations as simple and clean as many stories would have it. Indeed, there were both white and African American women who were members of both. The shatters were not clean. The Emancipatory Coalition held together and functioned as long as there was a core, unifying, tangible goal, that of ending slavery. Once that battle was won, and all the partners imagined they were at the beginning of a glorious reconstruction of the American polity where they could achieve their various desired goals, the movement splintered. The emancipatory organizations and coalitions, all of them, continued to reflect the best and the worst of the culture in which they were embedded. The racism, the sexism, the anti-Catholicism of the 19th and early 20th centuries, the anti-Semitism of the whole period. But I sometimes think of those people who actually held the power that whole time, the mostly white men who had their rights, who occupied most positions of political power, chuckling to see the struggles among the disenfranchised, fighting among themselves, because coalitions among the weak are so very hard to build and sustain. Thank you.
Thank you so much for providing us with some of that historical context. I want to now pause and open it up for discussion and invite attendees to use the Q&A function to pose questions to the panelists, and just to be sure that we start our dialogue, and then we'll get to the next two speakers discussing their papers. So as people start to formulate their questions, I wonder if you could both take a moment to reflect on the contemporary significance of these movements for emancipation, for suffrage, and even nowadays, often we reflect on, so many people forget about sovereign truth, right? And they think about this is very much a white woman's battle. And so what's the contemporary significance since we're in this moment?
Well, I guess I would start by saying that it's really important for us to look to the past at figures like Sojourner Truth and the role that she played in the suffrage movement, because as you just mentioned, there is still very much what I would call a spatialization of difference. And this is unfortunately true within the women's movement. One of the things that was frequently stated in the early women's movement was this notion of trying to create a broad and universal sisterhood among women. And we all know that while I think there were some valiant efforts to do that, that was never achieved. And what we can take from Sojourner Truth and figures like her, but especially from Truth, is that she's someone who is speaking on and talking about women's suffrage in the 1850s and the 1860s. And it wasn't until probably well over 100 years later that Black women could reliably vote. And yet she and other figures continue that work. So what can we take from it? On the one hand, I don't want to suggest that women of color, and especially Black women, should sort of just keep on working as what I describe proto-agonists, despite the fact that they may not be brought into full partnership in the suffrage movement or in the broadly and sort of umbrella feminist movement. On the other hand, I think women of all backgrounds need to recognize, as I said, there is no universal now. We are not there yet. That's what I think we need to take from looking at the history of the movement. And we need to keep going on that journey, notwithstanding any peace that we achieve. I mean, let's take, for example, the recent passing of Justice Ginsburg. There was this shining moment in time when we would have said, we have 3 progressive women on the Supreme Court. Now we are down to 2, and Supreme Court is on the cusp of becoming a very different institution. What we can take from the women's movement, what we can take from Sojourner Truth and her work, what we can take from it all is that this fight, again, the astrophysics term, the past, the present, and future, we are never there. This fight continues because periodically there will be something that comes along to disrupt it. So I would say that's the most important thing that one should take from figures like Sojourner Truth. There is no now, there is no there. This is an ongoing struggle for suffrage and for rights.
I would say, in answer to your question, the reason I was motivated to do this particular paper and use this social movements coalition social science approach is because of what I heard that my students in my gender politics and political science classes had learned about women's movements of the past. Somebody's taught them that African-American women were never part of the suffrage movement. Somebody taught them that all whites in the movement were racist. Somebody taught them during the 1970s women's movement that straight women and lesbian women and Black women and white women and women, they never ever got together and they all hated each other. And so to take the coalition's approach and say, look, no single organization is a social movement. A social movement is a loose connection of people who share goals, and they do work together sometimes. For example, Sojourner Truth, you just have to pick up any history book. She was a speaker at the very first women's conference in 1850. She was associated with both the American and the National Women's Suffrage Associations. She was right there all the time, and she was far from the only African-American woman who was. And there were organizations of African-American women, sometimes because the white women excluded them, and sometimes because African-American women had things to say and do from within their communities. Likewise, when I show documentaries on the women's movement of the 1970s, my students are utterly shocked when they see, Black and white women together, when they see self-identified lesbians and straight women working together. Yes, there were conflicts. Yes, there were hostilities. Yes, there were exclusions. But we're talking about movements where people often came together or at least worked in parallel. So, I think really taking a fuller view of history to understand, really something that Lolita was just saying. Politics is bloody hard. It is hard and it's messy. And every time people without power try to work together to gain power, it is hard and painful. And I think that's one thing that we all have to teach today, to remember of movements of all eras, of all types, where those without power are fighting for power.
Thank you. I want us to turn to some of the questions from our participants here. And we have 4 questions you can see in the Q&A. And I'd like to just throw them all out right now so we can be sure that we can answer it. And some we may revisit towards the end. So first we have a question from David Sipe. Betsy Clark on the BUSL faculty until 1997 emphasized the roles of religious revivalism and anti-slavery activism to inspire and motivate women, here white Northern women, to think about their own political rights and disabilities separate from their husbands. Does anyone on the panel want to comment about that? We also have a participation here by Rachel Tiven. I've been interested in how the American Women's Suffrage Association is perceived today, either as a nullity or as the good side of an argument about race. But they were actually much more conservative in approach than the National. Why were they so conservative? What about Stone and Blackwell and other influences we should look into? Another attendee says, historically, what stitches in social movements have been necessary, lasting for movements, especially women movements, and last and be effective. And finally, one towards Virginia Shapiro. Why is the story told the way it is? What's the contemporary value of telling it that way? And it's an issue I think you were getting to a minute ago on that great question from Kate Silva. So let's throw that out there, and we have about 4 minutes to discuss.
Lolita, do you want to start any of those? Once I start, I might not stop.
Yeah, let me just comment on the first question, especially about the role of religious revivalism and anti-slavery activism. Let's speak especially about religion. One of the things that I discuss at length in my paper is the way in which religion in particular was at the foundation of many of Sojourner Truth's spoken advocacy, both for anti-slavery, but especially in the women's movement. Why was that true? So let's take the phrase, while the water is stirring. As I mentioned in my comments, yes, that is an important metaphor, an important historic metaphor for the nature of politics, but it's also something drawn directly from the Bible, and it's a reference to a biblical passage that virtually every woman would have understood. There was a strong religious grounding in suffrage movements, and many of the women to whom Sojourner Truth spoke, that was what she was focusing on, but that was also an important part of her own impetus for participating. As I also discuss in my paper, Sojourner Truth was someone who, on the one hand, was deeply religious. On the other hand, people would have described her as someone who used her own independent experiences of life to inform her religiosity. And in fact, I describe it as womanist, which some of you may know is this understanding of Black women's religiosity as a broader sort of social, political, even legal movement. And so, yes, religious revivalism was often at the heart of Sojourner Truth's work and other Black women's work in suffrage, and indeed other white women's work. That religious revivalism often was paired with and merged with anti-slavery. The other thing is when Sojourner Truth would talk about the fact that Black women able to essentially get credit for the works done in their own body, that's a direct reference to Paul's letter to the Corinthians. And again, this is a New Testament reference that listeners would have well understood. And so yes, Northern women certainly would have thrilled to hear the biblical references. They would have understood that they were being directly spoken to. And yet Sojourner Truth, being a master orator, also managed to say, but look, it's also about specific experiences of Black women, and I need you all, Northern white women suffragists, I need you all to think about that as you craft this big boat that we call suffrage before we go sailing off. So I'll stop there.
In the interest of time, I'll just pick at a couple of these. If anybody wants to pursue this more, I've got a Zoom thing for lunch, and we could talk about some of it. On religion, Sojourner Truth. Remember, once she stopped being Isabella and became Sojourner, she was an evangelical missionary. That's what she was, and that's where her speaking came from. As far as lots of the white women in the anti-slavery movement, this was not a kind of secular justice thing. This was the Great Revival, the Second Great Revival. And so a lot of their work is framed, a lot of politics in that period is framed by the framework of the Second Great Revival, which also mushes together with what people have called the American religion. It's fascinating. There's a lot more to talk about. That was true, by the way, of Susan B. Anthony as well. The American and the national, Rachel Diven's question is really, really interesting. I think people like to hype up the American because the leaders of that weren't so virulently racist in their rhetoric, although when I look at the African-American women who were involved, a number of them were closer to the national because its politics were more radical, because its politics were more gender-focused. And I think it's a misunderstanding of both of them. The major differences really had to do with political tactics more than anything else. And the political tactics, I think, would probably put a lot of us on the side of the national, certainly me, rather than the American. So the stitches is finding unity. The major tactical question, pick any movement you want, women's movement or not. The major problem is finding what is that thing that is so strong that everybody says, yeah, I'm interested in all sorts of stuff, but this for now is what motivates me. And that's why the stitch is fragile, because if you start getting that goal, what holds you together?
Thank you so much for those comments. And I love how we're folding in comments and questions from the participants, and we can address them more in a little bit. Right now, let's turn to Corrine McConnaughy talking about hidden politics, women's organizing, and the shape of American democracy.
Okay, thank you. I'm gonna go full on social science here and share a PowerPoint, and there will even be numbers at some point, and I apologize in advance for that. Okay. Okay. So, but my book image is behind me and in front of you now, and so part of what I'll draw on here is on the work that comes out of my book on the suffrage movement, but I wanted to reach actually a little broader than my own work today. So I'm going to embed, what I think are sort of where I'm going to drop my book inside of the broader theme of the idea of hidden politics, women's organizing in the shape of American democracy. Are we forwarding? Okay. Okay. So in essence, what I want to ask about is, what if we were to consider that women might indeed be real, unique, and essential agents in the development of the capacity of the American state and the shape of American democracy? Did women, in fact, make unique contributions? And if so, why and how? To answer that question, I think we would need to consider how both their gendered location in their communities and their gendered legal positions incentivize both particular forms of political action and particular receptivity of the system to that action. So let me start with where we might look to find women's collective action in the 19th century that isn't maybe the typical place to start. In a sewing circle or society, that such organizations were actually sites of community production is not historical news. That they were sites of both political action and development of the state is perhaps news, at least to most of political science, where I normally sit. Women might use this space, as you can see here, about the women of Littleton, New Hampshire, doing not only to produce textile projects, but also to produce more permanent public goods, ones that other community actors perhaps had not yet prioritized, in this case, a cemetery. And importantly, they did so in form that clearly mirrored, and this is what you're seeing on the right-hand side of the screen, they did so in form that, by organizing form that clearly mirrored the organizational structure and processes of men's formal political bodies. In a society that's governed by rules or bylaws, with voting procedures, leadership structures, accounting procedures, and the like. This was clearly not just some ladies getting together to casually socialize while doing some social work who happened to stumble upon the idea that they might do something more. And yet, the constraints of gender on their activities were not only from gendered separate social spheres of doing politics, but also gendered legal positions. And although the sewing circle of women could raise all the necessary money on their own and identify viable potential cemetery sites, when it came time to actually execute contracts for the land for the cemetery, men needed to be called in. And men were then prone to do something that women today are perhaps still familiar with, to take over, particularly as the provided good became formally a public one. And an administrative unit of local government, still very much exclusively the domain of men only, became the site of ongoing maintenance and expansion of that public good. Of course, if we were to look only at that last stage, the stage of the establishment of the formal government structure, we would miss the women's contributions entirely. We would miss that women, in fact, decided this was the public good to prioritize, that this was what was necessary. We would miss that women's labor had made this both priority and financially realistic possibility. So it's in this sort of backgrounding context that I've thought about the lessons of suffrage politics. And I've brought with me this understanding of gender's influence on what we recognize as political work, where we bother to look for politics, and particularly for women doing politics. And so when I look for suffrage politics outside of suffrage organizations, and I want to look harder at exactly what besides women's suffrage was produced within and through suffrage organizations. I've landed on essentially three legacies of women's suffrage politics that I want to briefly talk about, three insights that emerge a little more clearly from me taking this particular view. One is women's crucial, but not parenthetical, but crucial political organizational work, women's political innovation, that their location produced unique insights about navigating systems of power, and women's doing of politics as women, but not united by womanhood, which of course Gina was already talking about in a coalition framework, which is the same one that I will adopt. Let me briefly state how I've conceptualized the politics that ultimately delivered enfranchisement of American women, to the extent that it did actually occur during the 19th and early 20th centuries. In short, because those men who controlled the apparatus of the state and thus had the power to extend the franchise saw little credible promise of a new voting bloc in women, and because the organized movement retained the ultimate goal of a federal constitutional amendment, which is well understood to require, and in ordinary political times, as in during times where states from the southern section of the country were not removed from the process, bipartisan support would be required. Women's suffrage was not a goal that could be achieved via the enticement of the future votes of women for a political party that delivered their enfranchisement. This political reality meant that women's suffrage as a cause and women's suffrage organizations needed to form. They needed to form what Gina was already talking about, these credible coalitions. But importantly, they needed coalitions with existing voters. So not just any coalition would do. It sounds simple enough, but in fact, this was both a challenging as a political idea and as a political reality. To be quite clear, though, the challenge was never that women organized as women had nothing to offer political partners. So just as we saw in the Littleton Sewing Society example, women's organizations were sites of unique political labor, of particular forms of fundraising that filled coffers to support political work, including, as you see on the left, in a description of abolitionist women's organizations, the production of material goods and the coordination of their sale, and of uniquely available labor. Women abolitionists were so often the foot soldiers of the abolitionist petition canvassing campaigns, because although they indeed had domestic workloads to navigate, they were not yet beholden to the structure of industrial time. Women canvassers were navigating the realities of what we now recognize as the, quote, second shift, but doing it not for paid work in the labor force and unpaid domestic work, but for unpaid political work and unpaid domestic work. By the time that the suffrage organizations were mounting their final push efforts toward the 19th Amendment, their own fundraising capacity had reached the levels of serious party politics. The National Association here on the right is the National American Women's Suffrage Association, which was operating in the neighborhood on a budget in the neighborhood of about $1 million a year, which, as they pointed out quite publicly, was about half of what a national party organization might spend in a hotly contested presidential campaign. Women in women's organizations could and did offer valuable political resources and labor, and it was skilled, including perhaps in ways that men were not equally. But also women were, over the time horizon of the women's suffrage movement, increasingly located within organizations with men. And so the story of suffrage politics is also about the increasing recognition of the value of women's organizing work within those organizations. So I'm going to take you really quickly through kind of how I see that in the details of suffrage politics over the horizon. By taking you through the timeline of one state quite quickly, Michigan. So I'm going to talk about sort of 4 eras of suffrage politics and what developed in each of them. In this first era, we have the definition of the partisan potential of women. And very importantly, in the American case, this is happening at the same moment and literally in the same debates as American politicians are coming to terms on the partisan meaning of the enfranchisement of Black men, so on the idea of Black suffrage. In the state constitutional debates in Michigan, for example, in 1867, we find delegates endorsing the view that Black suffrage is indeed, quote, a question of paramount importance to the Republicans as a party. And yet the delegates move on to consider the idea of universal suffrage, which would actually include women, and offer that topic not quite the same sort of political meaning. They describe, politicians from both parties describe women as similarly distributed in partisan terms as men, and thus the logic that their interests are sufficiently represented by the men in their lives holds. They say things like, quote, I say that the females are now represented at the polls. The vote deposited by men is but a representative of the principle. Or, quote, it is the general argument that women now have an indirect political power by their influence on men, end quote. And so again, these are conversations in the very same constitutional convention being articulated simultaneously. And I think it's important to understand that that's how the initial meaning it is given in partisan politics to women's suffrage. And so the issue goes nowhere, legislatively speaking. The political calculation continued to dominate that particular political calculation continued to dominate legislative and partisan politics on women's suffrage, even as official suffrage organizations were established. Standing on their own, such organizations conveyed little new partisan meaning for the cause. Okay, but once coalitions with other organizations were established, here in Michigan in the 1890s, we first get coordination with the WCTU. New meanings derived from the political power of the partners emerged, and yet we'll talk about how not all coalitions are equally likely to lead to success, and how ultimately finding the right coalitional partners is what's key to leveraging legislative success for their cause. Quite briefly, you can just look at the picture if you, and believe me about what the numbers are conveying as well. The first partnership with prohibition interests via the WCTU was a losing one for the suffrage cause. In a sense of what occurred is that the coalition provided the idea of a connection between prohibition and women's suffrage, the connection of the WCTU endorsing suffrage and working through their own organization for that cause, gave the cause of women's suffrage a new enemy. So that for the first time, actually, legislative votes are significantly shaped by legislators' connections to the liquor industry. It's not something that previously shaped votes for the issue of women's suffrage. I also point out something about the photo here before we move on. The WCTU, like the Michigan suffrage organization of this time, is indeed a political space only for women. And it's centered in civic or religious space, not explicitly in the space of formal politics. Here, however, is the next significant partner, the state Grange. This picture is a bit different. It's quite literally in formal political space. The state Grange was meeting at the state capitol, and there are both men and women present. And so this kind of coalition partner that becomes the key to legislative success finally for the movement. And it's this kind of partnership that is the end game tricky space for suffragists to navigate and to do so effectively. And I just want to give a sense of, well, does it, how do we know that that's indeed what mattered? Suffragists will tell us themselves in their own accounts of how they lost and then won. This is the legislative chair in Michigan articulating that, in fact, she knew she was up against a liquor lobby, and she knew she needed to have support, an electoral leverage-based support, which only partners like the Grange could offer. And this one just tells you that indeed that's what leveraged legislators to switch their votes. So the top of the screen here, this is how legislators, the influence of having farmers in your district influenced legislators' votes before the Grange got involved in 1909. Farming in the district does not structure legislators' votes. By the time the Grange has become actively involved in the cause, then we see that resistance is only possible where the Grange doesn't have a real electoral base of influence. So far, though, I think my comments, and so before I close, I want to make things more complicated than the salvo that I think I've offered so far about women's suffrage politics as a narrative of expanding inclusion. For the agency of women using a successful expansion of and provision of public goods, democracy itself, I want to remind us that while I noted that men and women were sitting together in the Grange meeting in the Michigan Capitol, and that political power came from that common location and the willingness of an organization with men's electoral influence to leverage that for their cause, there were no people of color in that picture. So I want us to remember that it was interconnectedness as the basis of political partnerships that ultimately won the women who did gain suffrage rights in the so-called woman suffrage movement. So it's just as notable and also essential to recognize the embrace of racial segregation is a cutting off of the path of inclusion for women of color. And I want to make it really clear that this was quite explicitly done within the suffrage organization itself, and that is also part of dealing with the legacy of women's organizing, and also of recognizing that indeed women might be doing the expansion of democracy in terms of where they are doing unique work as women, but also in terms where they don't necessarily embrace a common womanhood, and in fact are quite willing to advocate and innovate ways in which to exclude other women.
Thank you so much. Let's now turn to Kristin Collins to talk about citizenship by committee, women's nationality rights in the post-suffrage era. I think you're still muted, Professor
Okay,
Collins.
thank you. Thank you all for being here. I appreciate all of the hard work that Linda and Gina did to organize such a great conference, especially under such unusual circumstances. And I want to explain that my paper is set in the immediate post-suffrage period, so before the First and Second World Wars. So this is moving us closer to the present day. And this is as American women won the vote, and then they fractured and reorganized in different ways to take on different issues. And one of the issues that they took on was women's equal citizenship. And this was the feminist campaign to reform laws that governed formal citizenship status. Most discussions of this issue are focused on marital expatriation, the practice of expatriating American women who married non-citizens. But here I focus on children's citizenship. The laws governing the allocation of citizenship to foreign-born children of American parents were also sex discriminatory in the early 20th century. And to a certain extent, they continue to be so today. And those laws happen to have been the subject of the very last gender equal protection decision that Justice Ruth Bader Ginsburg authored in a 2017 case called Sessions versus Morales-Santana. In Justice Ginsburg's 27 years on the Supreme Court, the court heard actually only a handful of sex equal protection cases. And of those, 4 concerned sex discrimination in the citizenship statute governing foreign-born children of American parents. After several fits and starts in other cases, in the case Morales-Santana, Ginsburg was able to garner a majority opinion for the simple principle that sex discrimination as between American mothers and fathers in the assignment of citizenship to their foreign-born children, quote, cannot withstand inspection under a constitution that requires the government to respect the equal dignity and stature of its male and female citizens. So the questions I want to puzzle here are, why was the struggle for equal citizenship rights so difficult as a historical matter in the early 20th century? And why does it continue to be so today, even after Morales-Santana? In the immediate post-suffrage years, a possible explanation for those difficulties is that extension of suffrage to women did not make much of a difference to policy outcomes. This explanation would find support in the work of historians such as William O'Neill, who famously argued that women's suffrage had little impact on American politics. Now that theory has been challenged and debunked, and Corrine's work that we just heard of is part of that challenge. And here I want to make, though, a point that I don't believe has been made elsewhere, and that is to focus on the importance of institutional configurations that at the time empowered individuals and groups to resist change. I'm referring to things like veto gates in Congress. And the story of the early 20th century women's struggle for equal citizenship rights brings to light another institutional configuration that stymied political change, the bureaucracy. Put simply, the first part of my answer as to why sex-based regulation of citizenship was such a sticky problem in the early 20th century, it's bureaucratic resistance.
Not all bureaucracies are the same, but in this case, the feminists seeking equal citizenship rights had to tangle with a bureaucracy that was charged with the politically salient job of gatekeeping, the enforcement of immigration laws. And from the bureaucrats' perspective, that institutional mission was directly at odds with feminists' campaign for equal citizenship with respect to the children of American mothers and fathers born abroad. So how exactly did this struggle between equality feminists and bureaucrats play out? In the years following the ratification of the 19th Amendment, feminists wanted to end the link between women's formal citizenship and marriage. And as Gina Shapiro explained in an extremely important article she published in 1984, it's by 1922 and then 1931, the feminists had prevailed in significant part. American women would no longer be automatically stripped of their citizenship upon marriage to a foreigner. But, and this part is the focus of my scholarship, even after American women could retain their own citizenship upon marriage to a foreigner, citizenship laws discriminated against between American mothers and fathers. So in marriage, American fathers' foreign-born children had always been recognized as citizens, but not so for the children of married American mothers. And outside marriage, the pattern was reversed. Thanks to an administrative rule in this case, American mothers' illegitimate foreign-born children were citizens, while those of American fathers were not. Resistance to early 20th century feminist efforts to alter this gender and marital status-based arrangement was fierce. In 1922, the State Department's resident citizenship law expert, Richard Flournoy, declared the idea that mothers could transmit citizenship, quote, a proposition so ridiculous that it is hard to discuss. Now, the few historians to have considered this issue in these historical materials have concluded that Flournoy's position lost, and with good reason, because in 1934, feminists prevailed on Congress to pass the Equal Nationality Act, which equalized American mothers and fathers with respect to foreign-born children's citizenship. And around the world, this was called women's greatest victory. And Alice Paul was one of the leading figures in this move. And it was a victory, but it was short-lived. 6 years after the Equal Nationality Act was enacted, Congress enacted a new nationality statute, the Nationality Act of 1940. And with respect to citizenship by descent for foreign-born children, that act restored many of the traditional gendered family law principles to American citizenship law. Now, how did this happen? Administrators were the prime resistors, prime reactionaries to the Equal Nationality Act. Why was this? Because they thought that citizenship by descent had become a means to evading the racially and ethnically restrictive immigration laws that they had dedicated their careers to enforcing. This concern was paramount in the minds of Department of State officials in DC and in consular agencies around the world. In 1933, for example, Richard Flournoy, who I just mentioned, testified in Congress against the Equal Nationality Act. He worried aloud that the feminist bill would, quote, open the doors of the United States to the free and unrestricted entry of thousands of children of American mothers, including Orientals. Flournoy was worried about the enforcement of the Chinese exclusion laws. Others were looking eastward to Europe. In 1933, the Reich was rising. The Nazis had just enacted their own restrictions on sanguineous citizenship, excluding anyone of Jewish blood from German citizenship. The American Consular General in Berlin in 1933 worried aloud about the feminist bill, the Equal Nationality Act. He worried that Jewish American mothers in Germany would use citizenship by descent as a ticket to the United States for their families to escape the Reich. Now that was a problem in a State Department that was set on keeping Jewish refugees out. These issues, again, were not marginally important to the administrators. They were centrally important. And when it looked like the feminists would prevail in the Equal Nationality Act, the administrators of the Department of State proposed to Franklin Delano Roosevelt that they form a presidentially appointed committee to rewrite American citizenship laws. They even drafted an executive order that FDR signed in 1933. Basically, the executive order gave administrators the power of the pen. And the archival record tells us that administrators had seized the pen in an effort to kill the feminist bill. Now, of course, that failed at first as the Equal Nationality Act became law in 1934. But after 1934, the executive order was still in place, and the committee went on with its work with Richard Flournoy in the lead. The committee knew that it could not eliminate citizenship for the foreign-born children of married American mothers entirely, but it could and did restrict those rights. Put simply, it restored citizenship law was close to the original sex and marriage-based structure that existed before the feminists had started their equal nationality campaign. The contours of formal citizenship, those administrators devised in a statute that was passed by Congress in 1934, they were influential. Not only did the administrators write their gendered vision of citizenship into the law governing citizenship by descent, but also into statutes regulating immigration preferences and the naturalization of minor children with their parents. This gendered vision was durable. Until Morales-Santana, there was no legal constitutional restriction on how the political branches could regulate citizenship, naturalization, or immigration along gendered lines. Thus, when Justice Ginsburg wrote the majority opinion in Morales-Santana, she became part of this history that I've just recounted, rejecting the vision of gendered family that was first nature to people like Richard Flournoy. As was true of so many of Justice Ginsburg's opinions, Morales-Santana is both grand in its articulation of sex equality and narrow in its reach. It's incremental. Other statutory provisions with nearly the exact same gendered configuration continue to draw the line between citizen and non-citizen today, and unsurprisingly, litigation continues. And what I wish to emphasize here is that the barriers to further progress today bear some resemblance to the barriers faced by early 20th century feminists. The first wave feminists were fighting for equal citizenship rights in an era of xenophobia and immigration restrictionism, not dissimilar to our own time. And in this respect, context matters. What is almost always at issue in these cases is whether the petitioner in question can be deported. So an entire bureaucratic machinery rises up in these cases to challenge to meet the constitutional challenge. That starts with the very first immigration clerk who learns of the claim, the agency lawyers, Department of Justice lawyers, and officials who defend the sex-based restrictions on citizenship and naturalization in federal court, sometimes all the way to the Supreme Court. Now, thanks to the lawyer Ruth Bader Ginsburg, unlike in the 1920s, we have a body of equal protection jurisprudence that allows these would-be citizens to seek review in federal court. But so far, few circuit court judges have been eager to extend her reasoning in Morales-Santana. And at this moment, all signs suggest that it is unlikely that a post-Ginsburg Supreme Court will do so either. Thank you.
Thank you so much for that. We have 5 minutes for discussion, so I'd like to open that up for questions. And I've been tasked to be sure that we end on time so we can have a break and then go to our next session. So any questions from participants, or I want to invite all of the panelists to turn on their cameras and you can engage in dialogue together as well.
While we're waiting for people to ask questions, let me just underscore that Chris was responsible for organizing really important amicus briefs in these most recent cases. So applause to her.
I try not to write myself into that history, Gina.
But I can do that. You could mention that Ginsburg cited.
I'm sort of the participant observer.
I have a question, Chris, or maybe it's more of a comment. I was particularly struck and fascinated by what you describe as this ongoing tug of war about the nature of nationality by descent. I mean, so for example, you mentioned there comes this, what appears to be this great and shining moment when women are not going to be subject to these sorts of norms. And then you have the Nationality Act of 1940 that in effect, puts a lot of those restraints back in place. And it makes me think about the ways in which we in the contemporary world think about immigration and gender. We no longer have immigration by descent anymore, but when you think about things like the rhetoric around so-called anchor babies and the ways in which women's bodies are sort of used in this sort of socio-legal, socio-political way, it's sort of like what I was saying earlier. We are in the universal now. In short, clearly women have advanced in terms of the rights that they have regarding immigration and the birth of their children, but there is this ongoing effort at retrenchment. And I don't know if you want to comment on that.
Sure, thanks for that. So this is a chat, as you as the panelists know, my paper today is a sort of chapter in a book, and the book is preliminarily titled Blood and Nation. So it's about this longer phenomenon. And towards the end of the book, I will talk about anchor babies, that sort of phenomenon and that political rhetoric, So one of the claims of the book is that in its incredibly and often overlooked, at least from the immigration and citizenship side, important role that family and gender and family law among the lawyers involved has played in American citizenship and immigration law, not just after 1965, but well before that as well. And it's played that role both as a tool of inclusion and exclusion. So the struggle that I describe here is over, in this chapter, is over family status. And because family status is regulated by something we call domestic relations law or family law as a tool of inclusion. So who is included based on their family status? And this is a struggle over who will be included. And from the feminist perspective, the struggle is over the role of gender. But from the administrator's perspective, the struggle is really one primarily over racial and ethnic exclusions that they're desperately trying to enforce both towards China and towards Europe. Anchor baby and also antebellum, the chapter that focuses on the antebellum period, really is focused on family law as a tool, or domestic relations personal status law as a tool of exclusion, right? How can we write people out of we the people or the citizenry using family law? So family law here is not law in some kind of static sense, but is a tool that can be used by different actors who are positioned in different positions, as litigants, as lawyers, as writers, as legislators, as administrators in this chapter, to craft, a citizenry that they think, that has the priorities and bears the priorities, resembles the citizenry that they imagine as America. So that's the gist of the book. So yes, right, you get to the 20th century and you have the sort of problem of the illegals identified in the late 70s, early 80s, and the anchor baby rhetoric arises as a sort of shorthand for that, quote, problem. And the efforts today to restrict citizenship to children born within the United States. Some of those bills use exactly the same legal formulation that was produced in the 1940 Act, like to the letter. So it's a fascinating, and this actually, in some ways, I was thinking about, your statement, your meta statement about time and how time, how we understand time. And I think a lot about that as I write history. I don't think about it exactly the way you do, but certainly here, legal texts serve as a link between moments of time and our resources that people deploy over and over again. And lawyers are really good at that because precedent matters.
Thank you so much for that comment. And yes, let's hear from Gina Shapiro, and we'll wrap up.
Just to make a connection between the earlier papers and this paper, when I said that gender ideology and gender roles were becoming even more defined and the status of women more subsumed in that pre-Civil War period. If we go back to 1855, there's the Congressional Act that underlies some of what Chris is talking about, where it was clarified that women's nationality is completely subsumed under their husbands. And so that was really one of the signal examples of saying even women's nationality and citizenship is completely dependent on their husbands. And that, that happened in that period when there was greater and greater definition of gender difference. So that's a connection between our two papers.
Right. And I would just add, Gina, as you know, in 1907, it's reinforced yet again in the Expatriation Act. 1907, so 13 years before suffrage. And yet you have this incredible incredibly different vision of women's citizenship being codified in statute.
I want to thank you all for providing us with such a rich context, a historical context to go forward and have us think about citizenship in so many different aspects, and particularly all of the intersectional forces at play. And that really sets the tone for the rest of the conference. Thank you so much. Our next session is about teaching a history of women's suffrage, and that will begin at 11, and in the chat is the link. If you don't have it right at hand, and I look forward to you joining. Right now, please, let's thank all of our panelists today for setting such a wonderful, wonderful discussion already. Thank you.